Good afternoon. In accordance with sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. My name's Larry Clay and I'll be chairing today's session. Panel members today are Peter Reid, Dylan Reid, and Gary McKay. And our Deputy Secretary Treasurer is Nicole Ivanoff. We acknowledge the land we are meeting on as the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Committee of Adjustment public hearings are now conducted in a hybrid in-person and virtual format. Some applicants and participants will make their submissions in person, while others will participate virtually by electronic means through WebEx. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. Those who want to participate virtually and have registered in advance will be connecting with their computer or telephone and have the option of participating via video or audio. When your item is called, you'll be unmuted by the moderator. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. People attending in person today who want to receive a copy of the decision of the committee on an application must fill out a decision request card, and those participating virtually need to submit a written request for a decision by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies are permitted to appeal decisions of the committee. Appeal instructions are set out at the bottom of the decision. Today I'll call each item in the order listed on the agenda. Where an application is uncontested, the agent or applicant may proceed with their presentation if desired. When the committee does not require presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and/or take the matter into committee for a decision. Each speaker, including the applicant, will be given a maximum of 5 minutes to address the committee, and I'll comment when you're reaching the 5-minute mark. Any presentation or other materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept new materials at the hearing. When addressing the committee, please clearly state your name and address, and remember to confine your remarks to the matters outlined in the application. The agent or applicant will proceed first and make the presentation on the application. Then individuals either in support or oppose the application will be invited to speak. Generally, we call on speakers in the hearing room first and then those participating through WebEx. Committee members may ask questions of each speaker after they finish their presentation, and when all speakers are finished, the applicant or agent has an opportunity to rebut those issues that were raised by the speakers. This will mark the end of the discussion, and the application will be taken into committee for a decision. Madam Deputy Secretary Treasurer, there's no files to be closed this afternoon?
Through you, Mr. Chair, no files to be closed or withdrawn this afternoon.
Excellent. Any declarations of interest in the afternoon session? See none. And are there any deferral requests for the afternoon?
Yes, through you, Mr. Chair, we have a deferral request from the agent for item number 21, municipal address of 69 Oak Park Avenue, file number A0395/25TEY. And we have a late deferral request received this afternoon for item number 24, municipal address of 616 Delaware Avenue North, file number A0579/25TEY.
Okay. Can we deal with both those right now?
Through you, Mr. Chair, all of the registered speakers are here for item 21. For item 24, so far there is one person listed to speak in interest, and we do not have them available yet.
Okay, well, why don't we deal with 21 and then...
Through you, Chair, for the item number 24, person in interest is online now.
Oh, so we can deal with both deferrals right off the top? Okay, let's do that. Let's proceed with item number 21, 69 Oak Park Ave. This is an application to construct a new two-story ancillary building containing one garden suite in the rear yard of the lot. There'll be a total of 2 residential dwelling units on the lot, one within the main building and one within the ancillary building. The existing rear yard sheds will be demolished. Committee has before a copy of the minutes from the July 30th public hearing. Copy of plan of survey, revised site plan, floor plans and elevations, revised zoning notice from the agent, a deferral request from the agent. We have a staff report from Urban Forestry. We have correspondence and opposition from 67, 60, and 71 Oak Park Avenue. Do we have the agent?
Hello, good afternoon. This is Shahid Nanavati, and my address is 1304 Woodbine Avenue, Toronto.
Okay, sir, you're seeking a deferral. Can you tell us what the reason for that is?
Right. So although I had given the waiver, it was based on the previous zoning, which was taken somewhere in the month of May. Now the new zoning bylaws have come, and they've added 2 new zoning variances now. So it'll be difficult for us to send out the notice. So it was difficult because it came just about 8 days ago, and I had to request the treasurer for a deferment.
Okay, so you have additional variances that you need to bring forward, so that's pretty automatic. Thank you. Are there people here speaking on this item? Do you want to come up, folks? Yeah, sure. Are you together or are you separate?
We live at different addresses.
Okay, we'll just take one at a time then.
Do you want to go first? You want to go ahead? You go ahead. You go first.
Okay, sir, I'll need your name and address for the record.
Sure. My name is Richard Mendonza. Address is 67 Oak Park Avenue.
Okay. Now, sir, you've heard the agent. They are requesting a deferral, which means they'll come back at another time with additional variances. So we're not going to discuss the merits of it today. All I really need from you is whether you support or not the request for a deferral.
I actually do not support the request for the deferral. This is the second time the applicant has brought me down here, and they are now stating in the letters that they've complied that there are additional requirements that were made known to them. City Council passed those changes on July 24th of this year. Their last hearing was July 30th. They've had ample time to consider those issues. Additionally, at that deferral, they indicated they would be consulting with the neighbors. No attempt has been made to contact me, and I'm not aware of any attempt to contact any of the other neighbors to discuss this application. So it's on those grounds that I would ask that they proceed today with their application based on the information that has been presented to the committee.
That's helpful information, sir. Thank you very much.
Thank you.
Maybe if I can have the other speaker up. Hi,
Hello, Sherry Hebden. I live at 71 Oak Park Avenue.
right next door.
I do, yes.
And again, we're not going to be debating the merits of the application today. It is unfortunate, but the applicant has requested a deferral.
I understand, and I will endeavor not to repeat what my neighbor Richard said. I will add that in addition to the City Council passing changes on July 24th, Planning Committee passed those changes July 15th. The applicant knew or ought to have known about those in July. July 30th. The deferral was granted at that time on the condition that there would be consultation with the neighbors. They have not made any attempt whatsoever to consult with us. And you'll note that there's not a single letter of support of this application. I don't think they're consulting with anyone else either.
Okay, I appreciate
Could
I think I got your points.
I just also would like to say that there are a number of very inaccurate and misleading things in the application, and we think that it is somewhat deficient in that, for example, our house is not depicted as it currently is. There was a letter filed by the agent in May saying that we support the application, even though we, in writing, provided to the applicant that we did not support it in April. We have had to go through now 2 different plan applications, site plans, I think, not as planners or architects, and spent many hours. We have, I know that Richard and his family have, and have had to take time off work to write letters and to come down. And this agent is coming, it doesn't feel necessarily in good faith, because we're not coming here necessarily because we want to oppose, although we do. We feel that we have to come simply just to correct the record, and that to us does not feel like what the intention is of neighbors. That should not be the job of neighbors. So if there is a deferral granted, we would request that the owner be required to provide us printed copies of any revised plans in advance, that there be detailed annotations to explain the changes, that all plans are amended to reflect the proper size of 71 Oak Park Avenue and of all the auxiliary buildings that exist on the adjacent properties pursuant to the rules of the committee, which the current documents do not, namely the garage adjacent to the property on 67 and our actual house, which was renovated in 2020 and is not reflected. And we would appreciate 3D renderings to show the relative size of this proposed structure with the actual trees on the property. For example, the elm tree on the northern edge that the current drawing is built around is shown as having a canopy of approximately 8 feet. And it is, from our best guess, approximately 35 feet. It's an elm tree. So I'm not here to try to, slip it in or convince you of some, details. There are some significant deficiencies in what they've provided, and we have spent hours of our own time having to unpack it and bring that forward. So another deferral, I understand that is the correct procedural next step, and that the powers of this committee to force anything are what they are. But we would ask that there be conditions put and accountability for this application because of the myriad of inconsistencies and deliberate attempts to mislead this committee and to thwart the process.
All right, ma'am, thank you very much. Appreciate the input.
Thank you very much.
All right, that's it for speakers, so we'll take this into committee. I think,
I was going to say, I think we have to defer the matter, adjourn the matter, but we should really detail the conditions well in terms of what the neighbors should be supplied with, everything from, as mentioned, drawings and 3D renders, that sort of thing should come.
I'm just going to ask Nicole's input on this. What can we do? What are the obligations of the applicant relative to the neighbors?
Through the chair, so for the reasons for deferral, you can strongly encourage, sorry, can someone turn off their mic? Thank you. Thank you, sorry, we get feedback. Maybe you too, Larry, just for a second. Thanks, sorry, we're getting a lot of feedback. So through the chair, you can, in your reasons for deferral, strongly encourage that the applicant consult with neighbors prior to rescheduling, and that the applicant provide in writing correspondence explaining the consultation that has taken place and to what degree of providing revised plans or drawings to the neighbors or whatever consultation or not has occurred prior to rescheduling. We can't enforce the applicant to do said consultation, but we can enforce, or you can put the reason for deferral that before they come back to be rescheduled, that we would like correspondence detailing what has transpired.
Can we, I don't know if we can be prescriptive about what materials they provide to the neighbors other than what's required under the committee rules?
You can mention revised plans.
Right. But I mean, that may or may not include renderings. I think it's a legitimate point from the neighbors. We're seeing more of this where graphic representations are brought forward to the committee which don't accurately show adjacent buildings or neighbors and stuff.
Yes, and through the chair, you can add a note about correct any deficiencies on the plans as per the neighbors' concerns. Again, just to put it out there that it was noted from the neighbors.
Right.
We can't necessarily validate that, but that's in writing.
Can we, just one last thing, can we, I mean, usually that's in a copy of the minutes that come forward when this was brought forward, and the committee members get an opportunity to see that. Can we do something additional to that so that whoever is hearing this next time knows that the committee was concerned about the consultation?
Through the chair, well, the minutes are always provided in the package, so members would see the reason for deferral, as would staff. Prior to rescheduling, staff, the application technician assigned would be asking the agent to address the reasons for deferral or to explain how they have or have not.
Right.
You can also add a separate for the record
Right.
note, should you wish,
Yeah,
for the
okay.
minutes.
Okay, that's fine. Thank you for that. All right, I don't know who was speaking. Gary, were you speaking to that?
I was, in fact, I was thinking whether some costs should be assessed and added as an additional condition, but.
That's the lawyer in you coming out.
That's right, I think so. So I think, yes, the matter has to be put over, so I would move that this matter for 69 Oak Park Ave be deferred to a future committee meeting.
I think we want to put some conditions in it,
Yes,
Gary, if
agreed.
that's okay with you.
Please.
I would suggest that,
Yep.
that the applicant undertake efforts to have consultation with surrounding neighbors.
Good, yeah.
I think that another condition or another reason somehow would be that, that the agent or applicant provide a written summary of those consultations. And what else did we talk about, Nicole?
Improved plans or surveys, or addressing any deficiencies in plans or surveys.
Okay. Is that okay, Gary, with those conditions?
Yes, excellent.
Okay. Anyone want to second that? Or, yeah, Dylan? Okay, any further comments? Okay. Moved by Mr. McKay with those comments, seconded by Mr. Reed, all in favor. And just verbally to the agent, you've heard some fairly significant concerns raised by your neighbors. You would be well advised, I think, if you're going to come back to this committee, to have those discussions with the neighbors and discuss their concerns. Okay. The next deferral item was 24, was it?
Through the chair, the speaker in interest that has registered to speak is popping on and off line. They're not here at the moment.
Why don't we just deal with it when we get to it?
Yes, we shall do that.
Okay, that's fine. We're having technical issues here today. All right, we will start back then with item number 19, which is 565, 575, 585 Bloor Street East and 76 and 100 Howard Street. This is a application to obtain consent for a stratified severance and to create new easements and rights of way. Committee has before it a copy of the draft plan of survey, copy of plan of survey, site plan, floor plans, and elevations, 37 photographs of trees on the subject property, a covering letter from the agent, presentation materials from the agent, and a site-specific zoning bylaw affecting the subject property. We have email correspondence from Heritage Planning and from Community Planning, and we have a staff report from Development and Engineering Construction Services.
Through the chair, we have the agent here in person and one speaker representing the owner and will answer the questions only.
Oh, so there's no opposition then?
Through the
Okay.
chair, no opposition on this side.
Okay, all right. Oh, hello, sir. Good afternoon.
Good morning, Mr. Chair. My name is...
It's afternoon, sir.
Oh, pardon me. Good afternoon, sir.
No.
I've not had an afternoon coffee, clearly. Thank you, sir. The name is Adrian Frank, and the address is 188 Avenue Road, I am pinch hitting for my law partner, Jason Park, who's noted on the presentation materials. So we have a brief presentation for you, and subject to any comments or questions you have, those will all be my submissions. So going through the presentation materials, if possible, starting with slide number 1, overview of the addresses. Slide number 2, we have the municipal site. That's moving on to the aerial. This is Howard Street on the south side, Bloor on the north, and then Parliament Street on the eastern edge. So you'll notice that this is a fully developed site. What you're seeing on the screen is an existing condominium on the west portion of the property, existing condo on the east. What we're here to speak about is the ground level retail in between those two. So next slide shows you briefly that this site has some background. It was developed by means of a rezoning in 2013 to 15, and it notes that there are 3 portions to the subject site. If we move to the next slide, it's much easier to detail what these are. Sorry, one slide. There we go, this one here. The color makes this so much easier. We're dealing with a stratified consent only because this is a highly integrated mixed-use development with these 2 residential condos and the retail in between. On the screen, the blue and the red are the 2 retail portions that are the subject of this application. Those are the 2 severed parcels, which will, if this is approved, provide mutual easements relating to access and to matters of servicing and fire safety. A third parcel, the green, is a further retail parcel that benefits from easements that are provided solely for the purpose of some shared facilities that are involved. So moving on to the next slide, the technical elements of the application are parts 1, 2, 3, and 4, being what you saw in blue, which are to be severed and conveyed to the existing tenant of that parcel. And then the remaining parts, 5, 6, and 7, which were highlighted in red, those are to be retained by the existing owner, which is also the developer. The final paragraph there speaks to those easements in green. So we can flip through the remaining slides relatively quickly. The next one is a strata grid, I believe. Oh, and strata grid, which details the easements. These have been reviewed in great detail by city staff, as well as a host of experts that are hired by the applicant. And it's been confirmed that this all reflects both the existing operation and what we're proposing here by selling one of the retail parcels. If we flip through past those to slide number 12, this simply confirms, oh, pardon me, I guess my numbering's different. The one just prior to this confirms that city planning had no comments and approved the scheduling. Development engineering listed 4 conditions, none of which we, the applicant, and I as agent have issues with. We are comfortable having the committee approve it with those conditions. Subject to any of your questions, those are my submissions, and I commend this to you as an application that meets all statutory tests, represents good planning, and helps facilitate a continued successful operation on the site.
Okay, thank you very much, sir. Panel, any questions? Okay, it seems like a fairly straightforward technical amendment, and will satisfy the ongoing operation of this site. All right, thank you, sir. I don't think we have any questions. I'll take it into committee. Peter?
Yeah, thanks. I'm happy to move this. I think the presentation and the materials on file were very clear, and it's clear that city staff has no concerns with this consent. So I move that we approve the consent subject to the development engineering conditions.
Okay. Motion by Mr. Reed to approve, subject to conditions, seconded by Mr. McKay.
Through the chair, sorry, just to clarify, so that's the standard development engineering conditions or engineering construction service conditions, plus additional engineering construction service conditions that are outlined in their memo.
That's right.
Yes, thank you.
Sorry, thank you.
Okay, all in favor? Have your approval. Thank you for coming down, sir. Item number 20, 246 Markham Street. This is an application to construct a new two-story ancillary building with a skylight containing a tandem two-car garage with storage on the ground level and one laneway suite on the second story. In the rear yard abutting the laneway, also there'll be a new hard landscaping between the main dwelling and the ancillary building, and a widened driveway access from the rear lane to the ancillary building. There will be a total of 2 dwelling units on the lot, one within the main dwelling and another one within the ancillary building. Committee has before it a copy of the minutes of the January 15th, 2025 public hearing, copy of the plan of survey, revised site plan, floor plans and elevations, 7 photographs of the subject property, a copy of email correspondence from the agent, and we have comments in from Transportation Services and Urban Forestry. Oh, and there you are, sir. Good afternoon.
Good afternoon. Not as large as the last session, but thank you very much for deferring the January 15th. We had received forest.
Is your name
Oh,
and
I'm
address for
sorry.
the record, sir? Sorry.
It's William Joannou,
Okay.
Joannou,
All right.
30 Furnival Road, on behalf of the owner of 246 Markham Street.
Okay, sir. Yes,
Okay.
you were starting to tell us
Yeah,
about.
I'm sorry. I was just eager. I rely on cheat sheets because I'm getting older. Anyway, it was deferred last time. We had a very late forestry letter with objections and no support. And it revolved around a tree in the backyard that we had asked to remove, and no sod, which corrects the description of the project, hardscaping. We've resolved all our issues with forestry. We're keeping the tree, protecting it at substantial cost to reroute eventually services around the root system. And we've changed our hardscaping in the backyard to sod as requested by forestry. So I think that one with forestry is wrapped up. I checked the AIC yesterday and this morning, and there was no further comments from forestry or
Sorry,
anybody
sir.
else.
I don't mean to interrupt you, but
Mhm.
you said you're replaced in the rear yard
Yes,
hard landscaping with soft landscaping?
yes. That was one of the conditions of forestry.
But you're
and
still
we met
seeking a variance for 0 soft landscaping in the rear yard.
That's not correct because our new
Is there an
revised
amended,
drawings.
is there an amended zoning? No, this is the public, no, if you can pull up public, yeah, see that variance number 1?
We went back for a rezoning update, so there is a new notice to that effect.
We don't,
Number 1, I think, is related to between the rear of the laneway suite and the laneway. Yeah. It's
oh,
not-
you're right,
yeah.
Peter, you're absolutely right.
That's a separate issue.
Yeah,
Right.
no, fair enough, thank you for the clarification. So you don't have a rear soft landscaping variance?
No, the width of our garage door being larger because of the tight laneway, arcing cars into the ground floor garage. We've gone for larger door. Whatever's left on either north or south side is so minimal, and if you saw that laneway, there isn't a blade of grass for miles. It's almost impossible to achieve anything reasonable there. So we are still asking for the variance on the laneway side, but on the interior yard, rear yard, we've solved our issues with forestry and changed our hard paving there, which was a patio, to soft sod. But as a past item, the lot previously, that entire backyard to the laneway line, was solid concrete for 40, 50 years. So in our eyes, we've introduced a little sod where there wasn't, to the best of our ability.
Right.
Okay, so that's all resolved with forestry. We have a tight lot, very narrow. So we need a longer laneway home to achieve anything meaningful and to respond to the housing crisis. Very narrow, we've had to do a two-story scheme with higher ceilings, so our height's a little bit too high, but I think still reasonable. We're a little bit longer for the laneway home, but we wanted to achieve reasonable size rooms within it to accommodate 2 cars on the ground floor in tandem. So we're pulling cars off the street because of it. We're trying to accomplish a family-sized laneway home. There's no point introducing anything as a little bachelor or anything like that. This is to be a proper home for somebody. And we're also trying to meet the requirements of the city to find more infill potential. Our density and coverage a little bit higher, but this neighborhood, if you're aware of Markham Street, it's full of 3-story homes with all kinds of mishmash, garages and whatnot. The density is huge in that whole neighborhood. So our laneway home, even a little bit higher, a little bit longer, a little bit closer, would not change the character of the neighborhood at all. We've tried our best, but to be able to justify building this as an optional home, we just need a little relief on that. We do have a support letter from our semi-attached neighbor. Nobody showed up in the last hearing that was deferred against this proposal. Many neighbors in the neighborhood are heading in this direction as well. So it's not unusual what we're doing. Is it a tight condition? Yes, it is. But we're trying to achieve something here and introduce some more housing. And with that, I thank you and look forward to any questions or, an approval.
Thank you, sir. Any
Thank you so
questions?
much.
Just one quick question. Is it slightly larger than the original proposal?
Yes, it is, because under that regulation 642 that we discussed with the last panel, we could shrink it back to 4 meters and avoid the angular plane issue. So we uprighted the facade facing the main house, and no objection from any neighbors that we consulted with on that. So that was the direction we were heading in updating our drawings. And the reason why we went for a rezoning, not a rezoning, a zoning review update, which we're allowed to do.
Okay, Dylan, that's good. Gary?
And sir, you realize there's a urban forestry condition number 2, it probably relates to private trees. So urban forestry is asking for a condition.
It was a private tree, but it's over a certain size determined by them, and we hired an arborist, tried to go through the application, but they were well entrenched in their protection efforts for this tree. It's a weed tree, but it's okay. The owners backed off and said, fine, if it's not much of an issue, let's leave the tree, we'll protect it, and then when we go for permit eventually, we'll deal with protection of roots, how we service around it, and that's later, much, much later.
That's fine, just wanted to point out that, if we approve it, that's gonna be a condition. Urban forestry's got that condition.
Yes, the tree will remain. We've substantiated that in writing to urban forestry, and literally deaded out the application because it wasn't heading anywhere, and we wasted our money with the arborist to try to fight it, and we thought, let's stop the battle, or the owner thought, and let's just give them what they want. They want to protect this tree, they see it valuable, let's protect it. And we added the sod, which was another forestry condition in the backyard, instead of an equal stone patio shared by both homes.
Okay.
Yeah.
Any other questions? Guys, so you've made the point that you need the extra length because it's a very narrow lot. I'm just frantically
It's-
looking for, is it 5.02 meters? Is that the width of your lot?
I don't have the plans with me, I'm sorry, and I can't remember the
We pull up
exact
the
width,
site
but
plan?
it's like 16 feet. I think the lot is about 16 foot wide. roughly.
4.92?
Yeah.
So 16 and a half feet? That is a very narrow lot.
So to achieve the 2 tandem parking spots within the garage on the ground floor, which serves the main house and the auxiliary house, there's no point introducing an extra home in the neighborhood if there's no parking. And that Markham Street is very challenged parking-wise. So the owner said, okay, I'll build more, but I'll take 2 spots out of or off the street. And it bodes well for both the main house and the auxiliary laneway home. And they have storage in there, bike storage and everything else available for them. And all our mechanicals are on the ground floor, obviously, because we needed to preserve the second story for the laneway home. So that's kind of forcing our hand in a particular direction, and that's what we need a little bit of relief from.
Okay. All right. Any other questions, guys? Thank you very much, sir.
Thank you.
We'll take it into committee. Dylan?
So I find this just too big. It's very tall, it's very close to the main building. I don't, like, this is right downtown, I don't see the need to have a parking spot for the auxiliary building. If this was a single, and also normally when we see family-sized laneway suites, it's on 2 stories. I mean, a 1-story one is usually a bachelor. That's just how it is, because that's the normal size. So to me, this is oversized. You could do a 1-story, you could do a 1-car garage with a bachelor studio easily, and that would be a decent distance. And you could do that maybe not as tall, or maybe it'd be okay if it was taller, if it was further away from the thing. But it's very close to the main building, and also considerably taller than what our usual variance is for laneway suites. So I don't think I can support this.
Okay, anyone else? Peter?
Sure, yeah, I agree, Dylan. The length of it is a concern for me, particularly in that it actually overlaps the adjacent house, the front house. And I think that that's not really towards the intent of this bylaw. And I think the height plus the length makes it extremely overwhelming. I think there's nearly 10-foot ceilings on the 2nd floor, and I don't think that's necessary. So I commend the applicant for addressing the urban forestry issues and sodding the backyard. I think that's a meaningful move, but I still think what's being proposed is too much. But I think there is a solution here eventually.
No, your time's done. We're in committee, sir. I just say, I agree with you. I have written in my notes, too long, too high, too close. So, all right, let's look to someone for a motion. Dylan?
I'll make a motion to refuse these variances for the reasons I've described.
Okay, motion by Dylan Reed, seconded by Peter Reed. All in favor? Sorry, sir, your application has been refused.
Thank you very much. Do we reapply if that's the wish of the owner?
Yeah, you can certainly, do that,
to some
sir.
degree.
You can, and I think you heard the panel members saying that there probably is an application in here somewhere, a good project in there
Okay.
somewhere. So yes, you can revise your application and resubmit it.
Okay.
Okay.
Thank you very much.
All right. Okay, we move on to item number 21, but that's deferred. Item number 22. Is 246 Benson Avenue. This is an application to alter the existing 2-story detached dwelling by constructing a side 2-story addition with a ground floor deck and stairs and a side 2nd-story Juliet balcony. Committee has before it a copy of plan of survey, site plan, floor plans, and elevations, 2 photographs of the subject property, a covering letter from the owners, and a staff report from urban forestry. Okay, do we have the agent?
Through your chair, we have the agent online and no registered speaker for this item.
Okay. Hello, sir.
Hi, can everybody hear me?
Yes, we can. Name and address, please.
Syriac Alapat, 246 Benson Avenue. I'm the owner of the house.
All right, sir. Just hang on a second. This is just FSI, guys, so anyone need a presentation? No, we don't need it. Sir, we've read your application. We don't need an application today. We're familiar with the material, or we don't need a presentation today. We're familiar with the application. Before we take it into committee, is there anything you'd like to share with us?
Just that we're proposing a 1.8 meter, 6 feet east side extension on the existing dwelling, predominantly for a growing family with 2 kids. Zoning is completed with 1 variance. We're adding a small addition, and we're looking to do it on top of the deck portion, which has an existing concrete there. And yeah, so that's just it at a high level.
Okay. All right, sir. Panel, any questions of the agent? No? Okay, let's go into committee. Peter?
Thanks, Chair. I think this is a very good application. It's an extremely constricted site, and the fact that this is only triggering FSI and no setbacks or other variances, I think, is commendable. So adding this 6-foot extension, I think will have very minimal impact on the neighbor to the north, who's really the only one who would be impacted. So I move with approval of the application, subject to forestry condition 2.
All right, motion by Mr. Reed to approve, seconded by Mr. McKay. All in favor? You have your approval, sir. Thank you very much. Item number 23 is 1320 Queen Street East. This is an application to alter the existing 2-story semi-detached residential dwelling by constructing a rear 1-story addition, a front basement walkout with stairs, a rear ground floor deck with stairs, a rear 2nd-story rooftop deck. Also to convert the existing semi-detached residential dwelling unit into a mixed-use building by constructing interior alterations for a new commercial unit in the basement and a new 3rd residential dwelling unit on the 1st story. There will be a total of 3 residential dwelling units on this lot. Committee has before it a copy of the plan of survey, site plan, floor plans, and elevations, an arborist report, and we have comments from Transportation Review and Urban Forestry.
Through your chair, the agent is online and no registered speaker for this item.
Thank you.
Hi there. My name is Joseph Sayateki from Strata Design and Development. I'm the agent for Leanne Lublin at 1320 Queen Street East. I'm unsure if you want to do a full presentation on this. We've worked with community planning on this.
Yeah, I think we're probably fine without a presentation. We may have questions.
Sure.
Is there anything you want to share with us before we do that?
Basically, my client, the owner of the building, is looking at expanding her business. She had purchased this property with the intention of actually converting this back to the mixed use of the area. And a lot of the extension related to the rear yard setback minor variance is related to the need for 5 clinical treatment rooms in the basement for their business. That's the kind of the minimum that they need to operate it. And that just also helps with the creation of the additional dwelling unit on that 1st floor. We really tried to keep the scale modest, even though there's a lot of other mixed-use buildings. There are 3 stories, full lot coverage, just a few doors down. So the clients have also reached out to as many of the neighbors as they could. As far as I know, there's no objections. And we've also worked quite closely with the apartment building to the east of the site, which is Greenwood Court, and it's owned by CMHC. So the property management have been really great with us there. They've even let us place a bin for some of the interior waterproofing that's been going on their property. So we've been in close consultation with them on the arborist work, or the arborist report, and the potential tree injuries to the 4 trees. And as far as we know, as of today, we received the undertaking release from forestry as well on that application.
All right, sir. Thank you. Panel, any questions? I think we're good. All right, sir. Thank you very much. We'll take this into committee. Dylan?
Yeah, I really like this application. I think it's great to be bringing a commercial back onto a main street and adding additional residential. I mean, the length and the rear yard setback might be a concern, but I think this is pretty common on a main street, that there's really a very small backyard, or even often none. So I don't have a concern about that, and I thought the design was thoughtful. It's great bringing in extra residential space, and also looks great, I think, bringing additional commercial to the space. So I would happily move approval of these variances with forestry condition number 2.
Okay, motion by Mr. Reed to approve, seconded by Mr. McKay. All in favor? You have your approval, sir. Thank you very much. Can we deal with 24 now?
Through you, Mr. Chair, yes, because we are in order. So we are now at 24, which is the requested deferral.
Right.
Unfortunately, after multiple attempts to reach Diana Powell at 1211 Dover Court Road, we are unable to get them online.
She was opposed?
In interest, registered to speak in interest.
Okay. All right. Let me just read this into the record. 616 Delaware Avenue North. This is an application to convert the existing rear one-story ancillary building into a two-story laneway suite by constructing a second-story addition, as well as an interior alterations in the rear yard abutting the lane. There will be a total of 5 residential dwelling units, 4 within the main dwelling, and which is currently under construction, and 1 unit within the ancillary building. Committee has before it a copy of plan of survey, site plan, floor plans, and elevations, 3 photographs of the subject property, a covering letter from the agent. We have email correspondence from Transportation Services and from Urban Forestry. All right, we have the agent. Oh, hi.
Hi,
You're the agent.
I am the agent.
We
Hi,
finally
good
got
afternoon.
you.
Yeah, finally.
Oh, I'm sorry, and you were waiting for a deferral on top
I
of that.
was at
Okay.
2 o'clock, yeah, no, it's fine. So in short, we're looking for a deferral because we need 2 additional variances, which, so public notice needs to be recirculated. The laneway
I'm
suite.
sorry, I didn't get your name and address. I apologize. We
no.
got going
Right
without
away.
that.
Sorry, yeah. My name is Susan Mintz, and I'm at 417 Northcliffe Boulevard.
Okay,
I
go ahead.
am today the agent for this development. The proposed laneway suite is actually on the convergence of 2 lanes. And so when the zoning examiner did his review, he looked at the rear lane and did not contemplate the side lane. And so there are 2 side yard lane variances which actually need to be included. We, in our submitted, where my colleague put together the supplemental material, he foreshadowed that this might be a problem, and we reached out to zoning and said, could you look at this? And so it came back, and yes, in fact, it was distance from center line and an ancillary building with a laneway setback.
Good. Better to do it now than later, right?
That is
All right,
the
thank you very much, ma'am. I don't think we have any questions, guys. It's fairly straightforward. We'll go into committee. Someone want to move this? Peter?
Sure, Chair. I think that makes sense. I mean, we have to do it. I think there's a really good project here, and so I look forward to this coming back with all the variances in place. And so I move deferral with, move deferral.
Motion to defer by Peter Reed,
I'll
seconded
second
by
with a
Dylan
note
Reed.
that I appreciate that the applicant themselves actually noticed the variances. And,
Yeah,
and so I really, thanks for that.
yeah. That
Brilliant.
is good.
Thank you.
Thank you for coming down. Oh, don't I get to do it just by rote? All in favor? You have your approval. Technicality. All right, we move on to item number 25, 90 and 100 Simcoe Street, 130 Pearl Street, 203, 207, 211 Adelaide Street West. This is an application to alter the development standards for a 61-story mixed-use building by increasing the building height to 67 stories or 223 meters. The maximum gross floor area and a wind damper enclosure projection beyond the maximum building height, and as well as to reduce the minimum non-residential GFA by removing office uses. This and reduce the number of loading spaces. There will be a total of 1,003 residential dwelling units on this lot, including 46 affordable units, and it's subject to review under the related site plan control application. Committee has before it a copy of plan of survey, site plan, floor plans, and elevations, 21 photographs of trees on the subject property. We have a covering letter from the agent, arborist report, functional servicing and stormwater management report, pickup and drop-off assessment. We have presentation materials from the agent, servicing and grading plans, shadow study, transportation impact study, as well as the site-specific zoning bylaw affecting the subject property. We have email correspondence from Transportation Review and staff reports from Community Planning and Heritage Planning. And that is a long list of studies. It looks like you've done your homework. All right, welcome.
Thank you.
Names and addresses,
Good
please.
afternoon. My name is Lee McGrath. I'm the planner acting on behalf of the owner. I'm joined by Ryan Moore from Bentall Green Oak, who is a representative of the owner. He's also
Okay.
registered to speak should there be questions directed for him.
All right, man. You're asking for a whole whack of things here, so perhaps a presentation might be
yeah.
helpful.
And I'd like to, we can bucket those, as you see in the presentation materials, really into 3 themes, and I'll get to that in just a second. So I did prepare a few slides to provide an overview here. And as you read through all of the various studies, we've been working really closely with community planning for a number of months, as well as other departments, and come to a really great place with this application. And what I think is really important to center here is the opportunity to modify the site-specific zoning to really enable this project to happen. So we go to the next slide. So we're down at 100 SIMCOE, which is at Adelaide and SIMCOE, just west of here at King and Spadina. The existing site-specific bylaw dates from 2022. The concept at the time included an office component to take place in that podium that you see there, with a retained heritage base building and a tower above, reaching an ultimate height of 209 meters. And we're here to permit a few minor variances to that. And as you're likely aware, the market conditions driving the viability of office have changed greatly since the time of the initial approval. And so what Bentall has been contemplating, and what we're seeking here, is a change in the bylaw to modify the GFA, the arrangement of the GFA between the res and the non-res uses, and then associated variances that go along with that. And so through this, we'll be able to deliver more affordable housing, which is an excellent outcome. And then the variances, again, just relate to increasing the height, which is in keeping with the regime of the height in the immediate context. The loading is related to the change in the uses. There's no changes proposed to the approved heritage conservation approach. And again, an opportunity to secure additional affordable housing, which we think is a great outcome here. If we go to the next slide, I can unpack the variances a little bit more. So with regards to height, we are looking to increase the number of stories in the building to get to that ultimate height of 223 meters. There's some diagrams later in this package that show how this fits within the immediate context of tall buildings in the area. There's an exception for a damper, so this is an exception related to buildings of this height often require special mechanical equipment required to mitigate sway in a building of this scale. The GFA, as I mentioned, the site-specific bylaw had required an 8,000 square meter minimum for non-res, and that was related to the office component. And needing to change the balance of the uses within the bylaw is really what the GFA variances are all about. So that's what we're seeking there, related to the non-res and the res changes, but still requiring a minimum that reflects the non-res active uses at grade that we've been working with city staff to secure. And then the loading variance is a decrease in the proposed number of loading spaces, again, because the program has changed. So it actually complies with 569, it's just that we need to change the site-specific bylaw to fit the program. So if you go to the next slide, and if we can click on to the next slide, thank you. I'll just read off a couple of the heights and context here. There's a project directly south of us that's permitted to an ultimate height of 250 meters. The Forma project to the west, 305 meters. North and west of the site, an approval at 240 Adelaide for 219 meters. So the height that we're seeking is within the context and appropriate for this location in King Spadina. And on the last slide here, just wrap up the variances, meet the 4 tests of the Planning Act, and importantly, again, enable the delivery of the project itself, as well as provide an opportunity to secure additional affordable housing. I did want to take just a minute to comment on a couple of the letters and reports that you do have on file. We have a positive report from planning staff with the condition related to affordable housing, which we have participated in and understand. There's a letter from Heritage, and we note there's no objection to the variances, and that's stated in the letter, but there are comments related to the consistency of the design with the conservation plan. Our Heritage architects have already reached out to city staff and started to speak with them about, to really walk them through, because we think that we can come to an amicable resolution on their concerns. So that communication's already started, and that will continue through SPA and future processes. And lastly, a note, there is a letter of concern submitted by legal counsel for the neighbor to the west, 217 Adelaide. And I wanted to advise the committee that my client and legal counsel for my client both reached out to the landowner. The legal counsel had a conversation on Sunday this week. My client had a conversation with the landowner yesterday to walk through the proposal. They mentioned concern with notice. The notice was mailed on or before August 19th in accordance with the procedural bylaw. And all of the signs were present on the frontage, in fact, longer than required. So they will have been posted for 15 days rather than the minimum of 10. I see that they've requested a deferral in their letter, which in our opinion really don't think is necessary. The notice was appropriately given, and I believe you have all the information that you need to evaluate the minor variances against the test in the Planning Act. They mention a private agreement that they have with our client. Ryan's here to answer any questions related to that, but I don't think it actually has any bearing on the decision of the committee. So those are my submissions.
Great, thank you very much, ma'am. If I might, just a few confirmations more than anything. So you're reducing the total commercial or just office GFA?
It's described as non-residential.
Okay, but I mean, is that mostly office? Or is it office and commercial?
It was previously conceived as office. And what's now being contemplated is a retail space at grade.
Okay, so there's just commercial at grade, basically.
Correct, yeah.
And how much was that GFA in office reduction?
Previously?
Yeah.
Oh, it was previously 8,000 square meters.
And you're going down to?
Let me grab that.
So you thought this was going to be easy?
Non-res, 180 square meters.
Okay, so pretty much eliminating it. Okay. And you're adding, looks like 477 additional residential units, of which 16 to 18 are affordable.
Correct.
Okay. I did have another question, but it's just flown away. Any questions, guys?
I don't think we'd seen that letter of concern.
Through you, Mr. Chair. So just to clarify, speakers. So, ma'am, are you speaking to this item? You would like to speak? Okay, so we do have a speaker.
Oh my goodness, I didn't know that. Okay.
Yes, and through the chair, we have not received an official correspondence from this person. Yeah, so it's probably too late past the deadline. So that's why we don't have it in the folder.
I see,
but
okay.
we do have the speaker in person.
All right, well then, if we could, we'll just ask you to move back and we'll have you come up.
Sorry about that.
So I didn't have anybody on the list, so.
I have copies of the letter. I understand that we're not allowed to bring additional materials, but it was submitted yesterday. But my name is Caroline Jordan. I'm a lawyer at Stikeman Elliott. My co-counsel, Calvin Lance, submitted a letter yesterday on behalf of our client, which is the abutting landowner to the west, 217 Adelaide Holdings Limited, who is the owner of 217 Adelaide Street West. As they spoke about, our client had informed us that they did not receive notice, nor were they advised by the applicant that this application was being put forward. And we are requesting a deferral so that we have ample time to review the substantive amount of studies and information that's been put forward. I'd like to make clear that we're not opposing the application. We would just like some more time to review the materials and ensure that the principles of procedural fairness and natural justice are upheld throughout the consideration of this application.
So is there a concern from your client?
There isn't a concern, but we do have a proposed development that has been granted in principle approval from the Ontario Land Tribunal. And we just want to make sure that this minor variance application is compatible with the in principle approvals that we've been granted, and make sure that the developments will be compatible moving forward.
So that process needs to happen before these get approved, or
Yes.
could they happen in tandem, or
It
just
has
going
to happen
forward?
before.
Okay. Panel, any questions?
Yeah, I'm just wondering, like, I mean, the primary structure of the building is remaining the same, so I'm just wondering what you think could be an issue that might interfere with your plans.
Our client is concerned with several mitigation measures that were agreed to per the settlement agreement that was spoken about during the presentation. And we just want to make sure that those mitigation measures are maintained throughout the changes to the proposal.
Are there any specific variances that you think impact those mitigations?
This was only brought to my attention yesterday, so I do not have instructions to speak on that, and I haven't had the chance to review that.
Okay.
Gary?
Is one of the concerns wind then?
Yes.
I see. Great.
All right, thank you, ma'am.
Thank you.
Maybe folks, if you wanted to come up and speak to those concerns?
Thanks. Through you, Mr. Chair, I would suggest that planning would have considered, the approvals within the context when they provided their letter of support and evaluation of the application. And I wanted to draw your attention to the fact that the envelope, we're not seeking any changes to the setbacks, to the podium. The variances are restricted in that manner. So the relationship that the building had before at the time of the agreement with the neighboring landowner remains the same. And
With the exception, it's just a little bit higher.
The building is higher.
Yeah.
So in my view, the variances that we are talking about today are scoped and they're quite limited. And as you heard with the submission before me, they don't have a concern that they're able to point to with the variances. So if the variances are the subject of what you're able to make a decision about today, I don't see why that's not possible to happen.
The person in opposition raised the concern about the possible mitigation measures that were referred, I guess, part of the previous approval. So are those staying in place to your knowledge?
Through you, Mr. Chair, if you'll.
Oh, sorry, just get the microphone over there.
Through you, Mr. Chair, the mitigation measures were an obligation on the part of 217 Adelaide to implement on their site as part of the private agreement. So there are no mitigation measures subject to 100 SIMCOE. The private agreement speaks to BGO and Sun Life, the owner of the property, agreeing to a series of mitigation measures that will be implemented on 217 Adelaide. And we had reached out to 217 numerous times over the last few years since the agreement was drafted, up to and including September 2024, to try to negotiate the intent and the results of those mitigation measures. And those negotiations trailed off on the part of 217 around September 2024. We weren't able to complete that discussion, but we remain open to that discussion, and we always have been. We've tried following up, and we continue to be open to those discussions to finish that thought.
So just to clarify, oh, sorry, Gary, why don't you go? Just to clarify, the mitigation measures were going to be 217 things that they were doing, and your plans now don't impact those measures in any way?
Correct. The mitigation measures would have been implemented and will be implemented on 217 Adelaide as a result of the private agreement. There are no mitigation measures required on the 100 SIMCOE building.
Right, and nothing in these variances would affect the.
Correct.
Okay, thank you.
Okay, Gary, did you have a thought?
Yeah, just an issue about stories. This is my only kind of concern. So you have a site-specific zoning bylaw that was passed, or if it
Your microphone there, I can't hear you.
Sorry about that. So just to get, so it relates to the fact that you're asking for 6 stories. And I was going to say, sometimes this committee takes some heat from situations where it's felt that you shouldn't proceed by minor variance to add extra stories. Proposal sounds very good, but I just wondered if you want to address that, because the alternative would be like going back to OLT, I suppose, or putting in a new zoning bylaw application.
No, it's a great question. Through you, Mr. Chair, the 2 of those 4 additional stories actually result from compressing the office floor plates, floor-to-floor heights, from office to residential. So because office floor plates or floor-to-floor heights are higher, when you remove the office component, you actually yield more residential floors within the same geodetic height. So we remain within the same geodetic height for the podium. The additional 4 stories on top of that were a discussion with the city planning department, and in exchange for part of that was a conversation about the affordable housing.
Okay. Is the mix for the additional 477 the same as the mix before?
Yes, that is the intention. In the site-specific bylaw, there is a requirement for a minimum number of 3-bedroom and 2-bedroom units, and we're going to be consistent with that requirement.
Okay. Dylan?
Sorry, just one question. Was there any bike parking implications to the additional units?
No additional variances were flagged related to bike parking.
We will comply with the additional bicycle parking required by the additional units.
So there will be additional bike parking?
Yeah, that's right.
Thank you.
Any other questions? All right, let's take it into committee. This is not a new phenomenon, seeing the reduction of conversion from office. I mean, I wonder, with many institutions now requiring their employees to work more days in the week, whether that might be a short-sighted view, I don't know.
But it's up to them to make that decision.
It's up to them to make that decision, but this is not an uncommon type of proposal that we've seen in the downtown area over the last few years, because the market has changed.
I was going to say, like, as you know, I'm often concerned about requests for additional height through this committee. But in this case, I really think there's a lot of mitigating factors. I mean, first of all, there's no small, low-scale residential anywhere nearby. It's all tall buildings, or else, mixed commercial residential buildings. Planning is explicitly supported it, which I think was interesting. It's not always the case. Planning specifically said that they feel that it meets the requirements.
Right.
So I think that that's really valuable as well. And of course, the additional, it's not a huge amount of additional affordable housing, but I think it is helpful. And then I think the last thing is that the GFA increase is actually really small. It's 6%. So it's not like they're asking for a huge increase in gross floor area. So I think all those things mean this is eminently supportable. In terms of the request for deferral, I just don't, I hope that the two can continue to negotiate and work out any issues they have, but I do not see that this could possibly have any significant impact on the next door neighbor plans. So I feel like a deferral would be a bit of a burden, an unnecessary burden on this project.
Yeah, and I would note that there appears to have been discussions between the two principals over the course of years. Stopped, I guess, last year, but from our purposes, from our procedural perspective, it would appear that the requirements to post and notify have been met. So I don't think we have grounds to refuse to defer on that basis. Okay, all right. Sounds like we're developing a consensus. So, anyone want to make a motion? Dylan?
Sure, I'm happy to. So I'll make a motion to approve these variances with the heritage condition and the planning condition.
All right, motion by Dylan Reed to approve with those conditions, seconded by Peter Reed. All in favor? You have your approval. Thank you. Okay, we move on to item number 26, which is the last item of today's agenda. This is 50 Indian Grove. This is an application to construct a one-story detached ancillary building, a one-car garage in the rear yard abutting a laneway. The existing one-story detached garage will be demolished. Committee has before it a copy plan of survey, site plan, floor plans, and elevations, 2 photographs of the subject property, covering letter from structural engineer, and a previous decision affecting the subject property. We have email correspondence from Transportation Review and from Urban Forestry.
Through the chair, we have the agent online and no registered speaker for this item.
Okay, good afternoon. Jody.
Oh, hello.
Oh,
This
you're not-
is actually, this
you're
is
not-
Andrew from, can you hear me?
Yes, we can.
Sorry, thank you. This is Andrew from Batay Sharp Architects,
Great, sir.
speaking as the client's agent. So for this current C of A request is such that we actually received previous COA approval and permit for the project, which included a renovation of the garage in 2024. We were just going to replace the roof of the existing garage. During the construction process and demolition, you can see in the supplemented material, it was found that the existing tree had grown into the garage and had structurally compromised the structure. And so upon this, we got review from our structural engineer to deem that the structure was unsafe. And we went through a process of working with forestry and our arborist to actually reposition the garage away from the tree and fix the foundation problems. Part of our misunderstanding was that the procedure of deeming the garage unsafe structurally had to go through the building inspector before we could proceed with the construction. So he had to see it on site, not just through photos, and we were unable to do that. They demolished it once the structural engineer had deemed it unsafe. And so we're here today now asking for a variance of 0.36 meters from the rear setback. What we are doing is trying to rebuild the existing garage within the existing footprint, so smaller, but still the existing garage was 0.36 into the rear laneway setback.
Okay, thank you, sir. Panel, any questions? All right, we'll take this into committee. Jerry?
I think it's quite minor and that we can go ahead with this. I mean, the existing building, I think, had no foundation in terms of that old garage. So I would move approval of this variance application subject to condition number 2, urban forestry condition number 2.
All right, motion to approve by Mr. McKay, seconded by Mr. Reed. All in favor? You have your approval, sir.
And through the chair, apologies, can we just get the agent's last name? He
Batay Shorba. Andrew Batay Shorba.
Could you spell that, please? Oh, we
Yeah.
got it on the, okay. Okay, got it, thank you.
Okay, thank you very much, everyone.
A relative of some
We'll help
kind.
staff for the minutes, thank you.
Yep.
Thank you, sir. All right, that concludes today's agenda. We are adjourned at 3:53. Thank you, everyone.
Good work, everyone.
Yeah, good work.
Thank you, everyone. Can turn off your computers. Mute the room.
We
Seem to have a